thank you for coming over to Tel Aviv. We should also thank our dean here, Professor Grossman, for honoring this event. We'll talk this evening on the medicalization of international humanitarian and human rights law. Now, human rights law covers the old humanitarian law. And with an overview, we can talk about 4 phases in the interaction between medicine and human rights. The first phase, we can go back to the Geneva Convention. It takes medicine as a close, independent profession that needs protection from outside. Protection as a neutral, impartial human enterprise. So you have the law, international law, protecting the integrity of medicine. And then we have the crisis of Nazi medicine and other issues, the Tuskegee, also horrible war crimes elsewhere. And the idea was that human rights, or humanitarian law, then developing into rights, should guard us against medical crime, the excesses of medicine. So now medicine needs supervision. The third phase, I'll call it the bioethical turn. I mean, we know, as said before, bioethics, the discourse developing in the 60s and mainly from the 70s, has to do with the reaction of medical abuses, but not only. The key insight of modern bioethics is that we don't need Nazi doctors and Nazi regimes in order to abuse patients. Even well-intentioned and good-hearted doctors with excellent medical technology can still harm patients. And the debate about death with dignity and patients being stuck on medical technology and disregard for personal choice and culture, all this talk is developed in what I call safeguard against structural failures. It's not that medical technology is bad, the respirators work well, not that the doctors are abusive, they are well-intentioned, and medical law is fine, basically. It's about the protecting of the state in human life. But altogether, without these additions of new medical law and ethics, it can turn out very badly. So we have the idea of bioethics as a safeguard against crime and against structural failures. And there's also an aspect in bioethics that I call it utopian, and Samuel Moyn, historian of human rights, described human rights as a mixture of safeguard against worst catastrophe and harbingers of utopia. So when we talk about human genome projects and personal medicine and the big data and the ethics involved, then we talk about the bioethics discourse as something that is heralding a medical utopia. And soon I will talk about the medicalization of human rights. So we see that in the safeguard against crime and structural failures, human right is the leader. We need the shared foundation, fundamental value of society's shared language as leader. And here, biomedicine is the leader when we talk about medical utopia, how medical experts and science and ideas can show us a way to a better society. And there's a word for it in sociology, biopolitics, starting from Plato, how the experts, the doctors, can, with their ways of thinking and tools, transform medicine, transform humanity to a different modes of living. So it also has to do with a shift from persons to bodies, because law traditionally deals with persons, with abstract entities. And human rights started, the idea of human rights, about state sovereignty. And then it moved fast to the protection of real humans, of bodies, what we call the interval from birth to death. So human rights shift focus from state sovereignty to personal security. So you have the universal call of human rights. When we talk about the human rights of everybody, what is common to everybody, if it's not religion or culture or race? So it's the physical, biological human body. And who knows best about the biological human body? Doctors, what we call Sheila Jazen of bioconstitutionalism, somatic expertise. However, one of the key structural failures human rights come to redress in medicine is beholding people only as biological biological entities. And we'll see soon how things develop. And a key threat here is the move of human discourse away from narrative, as this is something built on Hannah Arendt, to algorithms and mathematics. We discuss less with patients, less about values, and more go directly to the language of machines in order to find answers. And we'll see what this will happen. And let's take an example, a concrete example. The Convention on the Rights of Persons with Disabilities, Human Rights Law. And if we read the preamble, recognizing that disability is an evolving concept and that disability results from the interaction between persons with impairments and attitudinal and environmental barriers, all this tortuous language tells us nothing about disability. The only material subject here is the environment. We are still in the abstract language of persons, that could be corporates. If you go by the preamble, a corporate could be disabled. It might work logically. But when we go to Article 1, then the definition must be more concrete. Persons with disabilities include those who have long-term physical, mental, intellectual, and sensory impairment. Now we move from persons to bodies. And who knows best about mental, intellectual, and physical impairments? This invites medical knowledge. And this convention is famous for its inclusiveness. So it requires a committee to follow of 12 experts that are recognized in high moral standing and competence and experience in the field. And it requires participation of experts with disabilities. So that's great. It's the first convention that requires representation. As the people with disabilities says, don't talk about us, talk with us. But the structure is still, in a way, strange. Because this committee is a committee of experts. If you are a disabled person with high moral standing, you cannot serve in this committee. You first must be an expert, recognized by other experts, which has the risk of going to celebrity endorsement. And we will see soon. So we have what's called biopoliticization of human rights, that the epistemic authority of the sciences is the medicalization of human rights altogether. So if we ask what conditions count as disability and how much, how you are 70% disabled person, and this kind of language, which people count as disabled once we have the titles, are certain conditions such as personality disorder, alcohol use disorder, disability. Who decides such questions and how? Before going on this theme, I wish to give more concrete examples for the medicalization of human rights law. And from these examples, we will see what it means. And let's take up a few examples. First, torture. There's plenty of literature, incrimination for war crimes for torture. Since the tribunals for human crimes in the Balkans depend on the medical records of victims of torture or alleged torture. And the Istanbul Protocol that the UN Commission for Human Rights set up for investigation of torture requires examination by healthcare professionals. So you think that torture, as it once said about the Bernard Williams, who was a famous philosopher, was chaired a commission in the United Kingdom and a public committee on pornography. So some said pornography doesn't need definition, you know it when you see it. So we think that torture is so abhorrent, you know it when you see it. But now human rights law wants doctors to write that it's torture. Refugees. The Convention on Refugee is explicitly in the language of bias, of the abstract language, because a refugee is a person persecuted for reasons of race, religion, nationality, membership for a particular social group. So a refugee is a cultural phenomenon. It has nothing to do with the body. Animals cannot be refugees by these standards. But in actuality, many countries today, France for example, grant refugee status to people with medical conditions. And people now in Europe, in the past few years, waiting for the process of their asylum requests. They wait and wait and wait. Who gets priority? Those that have medical conditions. Who is serving these people? NGOs filled up with doctors. Often, decisions about asylum status is not made on the basis of the person's status by the convention, but the government and the authorities default for medical. The doctor says he needs it, we grant it to him. We don't need to face the political and other issues that really involve with the decision of refugee status. Jews in Bellow, like the Israeli blockade in Gaza, there's a whole team of experts calculating how much food is needed in Gaza so as the blockade not violate the basic human rights for security. How can you do this kind of mathematics? Let's see, Jews at Bellow. So we have a study, medical study, with the question how many excess mortality was brought about by the US invasion to Iraq. And two excellent teams of epidemiologists conducted surveys home by home and calculations. One was published in New England, one by Barilan, excellent journals. And we see the results. According to one study, 150,000 people excess mortality, and for the other study, 650,000. It's fine as research, but when the implication of this publication is that the numbers help us decide whether the war on Iraq was just, we are in a problem here. And we're in a double problem when we see the outcome, because no clinical guidelines would be issued from studies that are so much convergent. We have 500,000 difference here in calculation. And you wonder whether medical knowledge and methods stretch a little bit the authority. Sometimes the outcomes are unpredictable. For example, the Human Genome Project is related to the question of Jews at Bellow. If you know how this project began, it was in the 1980s when the federal government was concerned with liability and with other issues related to the health damage of exposure to radiation, to the nukes. And they asked scientists, how can we evaluate the mutation that might... And they came out in a secret meeting in Colorado that there's little known about the human genome. And then lots of money was granted to sequence the human genome. At the end, it's a wonderful project. It turned out to be part of medical utopia. And people are not concerned anymore, maybe some secret project of the Pentagon, about the original intent. But this is a typical example where concerns about justification of war, justification or claims about war victims propelled a huge scientific project. And there are other examples. Hunger strike, something I published on, was torment in Israel. So the European Court of Human Rights ruled that if force feeding is necessary to save the life of the striker, it may be done. It's licit. But if it's not necessary, it would count as torture. Who would decide such a thing? And what's tougher decision? I mean, you have an error in your medical judgment. A second, you save the life of people. And then you miscalculated, and torture is the worst crime on the list of humanitarian law in any books of law. So we have here the evolution of expert authority. Historically, we had the ordeals. Old times. Ordeals might be nonsensical, that we go to the oracle, we check the entrails of... But there's one good thing about the ordeal. It works when there's consensus. We fight. There's a big fight here. The Philistines and the Israelites cannot get into peace. But they agree on one thing, that if David and Goliath fight, the winner takes all. It's a little silly, I think. But if this is the agreement you reach, it could be efficient. So this is an oracle. But civilized societies resorted to judges. Judges were the expert. They were expected to exercise rational inquiry and moderation and try to achieve compromise. And this is the classical model for conflict resolution in civil society and democracy. Expert witness entered the legal system in the 18th century in common law, with engineering, not medicine at all. And then we had the consolidation of what's called epistemic communities, like Society of Cardiologists. They come from Japan, they come from United States, they come from Germany, from Russia. The political relationship among the countries do not count, religious issues do not count. They share the knowledge of cardiology, the common language, the capacity to agree about these things. And then we had, for example, the first act of legislation in the world where experts from different countries and lawyers and politicians were working together for international legal guidelines. It was happening with the international labor organizations on occupational health after the First World War, which was a great moment. We take these activities for granted, but after the crisis of the First World War, the European societies, the epistemic communities would not accept German scientists after the First World War. It was a big debate about it, and then we all set up standards. There are contemporary standards for experts, of course, we're not going to it now. We have mixed human rights and expert panels, as the UN set up for the fighting trafficking organs, but sometimes we have experts that act as oracle of medical ordeals, and this is a great concern. The new oracle ordeal. Typical example is a resolution from the Pan American Commission on Human Rights is a case of rape. And he decided that the medical examination, gynecological examination, is the gold standard in determination whether rape has occurred. In that case, the victims were examined 20 days after the event, and the description, if somebody goes on the internet and reads it, the emotional trauma that these women, that were 16, showed in the examination is horrific. It's a real ordeal. So we have human rights have no firm normative basis beside the natural self-evidence and basic values, and we all know it. It's like the American Constitution that we all know that humans, what is this all know? Human rights are especially uncertain in situations of necessity. War, what should you do when is the defense of necessity works when you have a ticking bomb and you wish to torture, this kind of section. Traditional medical ethics is ready to deal with choices of the lesser evil. I mean, that's medicine. I perform abortion, I take the drug from one patient and give to another. That's all style medicine. Medicine is about necessity. And there's a long interaction between dealing with the lesser evil, diffusing from the ethics and law of war and medical ethics and so forth, like the development of the principle of double effect. It developed in the laws on war and was absorbed by medicine. Medicine has the authority of in-depth professional exam. That's how the Pan American Commission described how well the gynecological exam of this woman was. So we can do in-depth professional exams. The law and medicine are enthralled by the alliance of bureaucracy, information technology, and high-tech industry. We live this reality. Decline in public trust in politics and social institutions renders medical authority, especially authority grounded in sophisticated technology and big data, a disguised alternative to public discourse, like the refugee problem. In the absence of corrigibility, that's ABC of public deliberation, that you can correct yourself, society shifts from one ordeal to another. So we go for false accusation. People were exonerated by DNA exams and were saved from the death penalty in the United States. We all heard about these cases. What is the conclusion from this? One conclusion is we see that the best forensic exam is fragile, DNA testing is fragile as well. But this is not the most common reaction we see. More often, I am worried here, now we find the best test. You do DNA, everything is failure proof. So we take our science that has limitation and tend to turn the best of science into a kind of ordeal. And this is the key problem we have here, logically. In this alliance of medicine and human rights, each party tries to resolve inherent normative, epistemic, and structural weaknesses by relying on the other's reputation for probity, certainty, and efficiency. This situation is further problematized by the expectations of medicine to arbitrate human rights issues and of human right to restrain medicine. So we got each guarding the other. More troubling still is the invocation of the epistemic authority of biomedicine on issues about which evidence-based knowledge is lacking and professional training is quite efficient. So, I will jump here to save time. Let's go back for here. Torture. Doctors has to do this exam. I am a clinical doctor. Some of you have never been trained in the identification of torture. I don't know how many gynecologists know. Is there any reliable science of determining whether a woman has been raped 3 weeks prior? Hunger strike. Do we know when it is necessary to save the life of a person on starvation for 50 days? Is there any evidence-based science here? That we are cooperating with these kinds of judgments that we are not particularly capable of making? But judges often find it easy to default to doctors, and I'm also doing expert witness of the court, and they press on me on prognosis and other things. There's no evidence. We have a real issue here. The conclusion is that the collaborative and regulative interaction between human rights, law, and medicine may be of benefit. I don't deny this. I don't suggest that the doctors go away and populist politicians or models or religious priests take the place. However, we have to keep in mind law's attraction to the epistemic authority of medicine and of medicine increased reliance on the normative authority of human rights law. The alliance of medicine and human rights is often necessary, but especially when basic human values are at stake, it is on the verge of instability. Medical knowledge and authority might be the fairest and most reliable, and still the most magnificent structure cannot bridge a gap too wide for its current span. And this is the image, if you see before, that comes from Alice in Wonderland. How do I go up? To finish this, the Mad Hatter, because you have this scene that the watch stopped, and the Mad Hatter said, "What did you do?" "I put butter on the watch." He said, "Who puts butter on the watch?" And he said, "It was the very best butter." So human rights issues are really extremely important. I don't gainsay how important they are. And doctors or biomedicine might be the very best society might produce, but they still may not replace our inescapable need for democratic, political, and rational deliberation. That's the only instrument we have when no fear, no knowledge exists. Thank you very much.